Welcome everyone to our LinkedIn Live. I'm Adam Bloomberg, Senior Client Success Advisor here at IMS, where we help litigators gain a competitive advantage. I'm excited to introduce a discussion between our very own Chris Dominic and trial lawyer Craig Thompson. Now, some trial lawyers win cases, others shape the future. Craig Thompson does both and then some. As a partner at Venable in Baltimore, he's earned a reputation for masterful courtroom advocacy, delivering high-stakes victories that leave a lasting impact. But Craig's influence doesn't stop at the courthouse doors. He's been the president of the International Association of Defense Counsel, the campaign chair for Governor Wes Moore of Maryland, and now leads the Maryland Stadium Authority. Few people move so seamlessly between law, politics, and public service. So today, we're pulling back the curtain on Craig's unique path, his philosophy on advocacy, and what drives him to succeed at the highest levels. Chris, handing it over to you.
Thanks, Adam. Craig, good to see you.
Great to see you, Chris.
Hey, as we just heard, you've held all these positions of leadership, basically, in law, politics, public service. How do those experiences come together to inform the way you communicate, persuade in basically all of the different modes you're in?
I think it boils down to having a sense of purpose, whether it's in the practice of law or public service, community service, civic engagement, or with my family. The idea that you're doing something with a purpose, and that you're doing something that you believe in and that serves as your why, that serves as the foundation for everything. So I think that when it comes to advocacy, trial work, once I establish with a client, with the colleagues, that sense of purpose and why, that fuels everything.
Yeah, the drive.
The drive.
Yeah. So, something I've always wanted to ask you, from the work we've done together, we'll be doing something strategically. One of the things I've always noticed about you is what a strategic approach you have. And we'll be doing something that's got to be done. We'll be going through the strategic process. It'll be us and a bunch of attorneys all working together. And we'll adjourn after talking about things like, all right, what values are we driving to motivate jurors? And how are we making sure to maintain our credibility? How can we be the most credible team in the room?
Right.
And people will walk out, and I'll be getting my notes, and I'll look out, and and you're sitting right there, and you're ready to ask some more questions.
Yeah.
And I've always thought, whether it's framing or any of these more communication nerd issues, you always want to know more. Tell me a little more about what's going on there.
I think I may have told you this before, Chris, but I'm still searching for the doctor who split us up at birth, because we're definitely twins, and we're separated at some point. So I'm hoping to find that doctor and let them know how upset I am. But I do find how similar we are in our thinking and how we nerd out on certain things together. The concept of framing, storytelling, positioning is huge and part of my approach to trial work. And when you raise the concept of framing and compared it to political campaigns, for example, we even talked about certain political consultants, that's something that struck me, because in trial, just like in storytelling, it's not necessarily what you say, but how you say it. And so that concept of framing is very important. You go into the grocery store and you see, beef or pork or some kind of meat and two packages. One says 80% lean, the other says 20% fat. Same outcome, but messaged differently. Which one do you choose? And that's the object of framing for me, because as trial lawyers, it's really about the evidence, how it's presented, and what the message is that you want received. And so that's been part of my practice for years. And then when I found someone who was simpatico with that, as a consultant, it was like, that's my guy.
Yeah. By the way, I love that example. That's such a good one. You and I have talked a little baseball over time, and we've talked about the difference between elite ball players and great ball players. Like, what is or good ball players? What do you think of the characteristics of an elite trial lawyer compared to, say, a very good trial lawyer?
It's a great question. My initial reaction is, and my thinking is, in movies, storytelling, books, things like that. So my visceral reaction to that question makes me think of The Wizard of Oz. Bear with me. Because each of us have the three qualities of a brain, heart, and courage. We all have that. All trial lawyers have that. Brain, we're all smart. Courage, we have to kind of overcome obstacles to get where we want to go, and a heart, passion. I think what separates the good from the great to the elite is the extent to which you lean in on those three traits. So the great ones, the elite ones, they show a bit more courage. They go the extra mile, they go there. A bit more passion and connection to the issues that they're facing, connection with their clients, connection with the jury. And then, of course, the idea of having a brain and being intelligent and relying on your smarts, your instincts. And so I think that all of us have kind of those basic traits, but what separates the good from the great, from the elite, are the extent to which you lean in on those inherent traits.
The Craig Thompson Wizard of Oz leadership model.
Love it. Love it.
Yeah. All
And
right.
it's really kind of cool that you go behind the curtain in the intro. We didn't practice that.
No, it's true. It's true. So, okay, we've worked on some long trials together.
Yes.
And one of the things I've noticed over the years that in my practice is just how attention span has changed, right? And you and I have talked about this. What are you doing these days to try and compensate for the fact that the unnatural communication environment of a trial can be really challenging to jurors in terms of attention span, memory retention, all that stuff?
There's a great book called Made to Stick by Chip and Dan Heath, I believe is the last name. Great book. And it talks about the importance of messaging that sticks, using storytelling, analogies, metaphors, alliteration, words, things that will continue to stay in a juror's mind and a fact finder's mind. And so I think that's how I do it, and that's how I talk to other lawyers and colleagues. I want to make sure that we're telling stories that stick. So when we are working with our witnesses, we may use some analogies that have been used in opening or that they're familiar with that might stick, so that so there's an anchoring that takes place. So you have a basic message, a basic story, and every part of that story, every teller, if you will, of the story comes back to that anchor and that theme, and it sparks something in the fact finder. Say, oh, I've heard this before. Let me pay attention, as opposed to just a random set of facts and evidence that don't come back to an anchor.
Mm-hmm. That's a great example of that. It's basically priming being used very deliberately.
Exactly.
Yeah.
Exactly. And being intentional about it.
Being intentional about it. Part of the strategy.
That's right.
Yeah.
That's right.
So, this is one I've been dying to ask you too. What's one of the most challenging decisions you've ever made during a trial?
Those challenging decisions usually come either during opening or during closing, because those are the times when you are speaking directly to jurors. Voir dire, of course, is one of those opportunities, but in terms of the messaging, those are the times when you have direct contact eye contact with jurors. So the most difficult decisions that I've had to make are whether I want to go there now, and if I do, I have to live with it. And so whether it's sort of bringing in controversial subject matters, saying something that could be perceived as paternalistic or just kind of phony, making a reference to a local location, knowing I'm not from there, maybe pronouncing something wrong. It's kind of making that decision in the moment. Like, am I really ready to go there? Because once it's in the environment, I can't take it back. And so those have been some of the more challenging decisions. Do I want to go there right now? And if I do, am I ready to live with it?
That reminds me of something that we worked on together where I was very impressed with your courage. You knew that there was an opening to be able to collapse to your best issue. But that makes a lot of people nervous because that looks like you're not covering the issues, but it is just closing, right? Everything's in the can, as they say, but in terms of persuading jurors today, what do we have? How can I argue I won this trial?
Yeah.
And I remember the line that you used was, the day they lost was this day, and it was at this time when this expert was done with their testimony because they didn't do this. And I just thought it had to have taken a lot of guts to do that. Tell me a little bit about what happened. Like, what was the reasoning, or was it a gut call? Tell me.
Absolutely a gut call. And, just like I'm looking you in the eyes, when you're looking jurors in the eyes, you can kind of get a sense of their flexibility and their trust in you to kind of go there. And if you make a mistake, you make a mistake as their friend, or someone they trust, I should say, maybe not a friend. Mm-hmm. And that particular moment was just kind of reading the room and understanding that this was my opportunity on behalf of the client to state our truth and to say at this moment, and you remember this is when X happened, and kind of go from there. And once you see a couple of nods or some affirmative reaction, that's when you know, brain, heart, courage, that it's time to lean in.
Yeah, that's great. And you have to, the delivery has to pull it off, right?
That's right.
You've got to really, you've got to get there. You've got to be all in. And I think...
And you have to be sincere. I mean, that's the thing. People can sense when you're not being sincere about something.
So true.
Yeah, because another part of that trial was kind of going there with a very sensitive area when we were talking about civil rights and kind of comparing that to the legal system and the issues that we were dealing with in our trial. And so it's once you're given permission to tell your truth, you should lean in.
Yeah. If we used a football analogy, you had to make the long pass, but the guy was open. So yeah. So,
which is more pressure sometimes.
So I know. That's really true. So true. Okay, so what's a piece of advice you received really early in your career that still guides you today? Like, it's stuck.
The concept of this too shall pass is real. As younger attorneys and younger professionals, everything is taken personally and means the end of the world, or that you're the greatest thing since sliced bread.
That too shall pass.
That too shall pass. And so I think that in order to kind of maintain a level of stability and credibility and comfort with who you are, you got to realize that whether it's the greatest of highs or the lowest of lows, it's going to pass, and there's going to be another opportunity to demonstrate your greatness. But don't think that because of past failures or successes that's going to be a consistent. Mm-hmm. And you gotta let things go.
Yeah, it's a good thing you had good mentors.
Yes.
If you could, this is kind of a different way to say this. So not your mentor, but you. Mm-hmm. If you could go back and give advice to yourself, to a young trial lawyer, or maybe a new young trial lawyer today, other than what you just told me, what would it be?
Don't want to get too existential or mindful, if you will. That's the kind of term these days. But I think I would tell my younger self to understand the importance of breathing. And there were times when I was younger where I would kind of hyperventilate or get kind of caught up in my own anxiety and frustration because I wasn't breathing properly. And it's only recent, or more recent, that I've understood the importance of just taking a deep breath and allowing things to manifest and come about and then walk into it. So whether it's before a golf swing or before a speech, before coming here with you, and certainly before, getting up and standing in front of a judge or jury, just breathe.
Yeah.
Let it in, and then go be great.
It feels like one of those places that just nobody talked to us about that when we were young, kind of thing. But it's real. I read a book on it not long ago, and it was really powerful.
Yeah.
So yeah, that's really.
It's important.
It's
important.
It is. All right. So it's been great talking with you today, Craig. I really, really appreciate
It is always a pleasure.
the ability to get together and talk about this. Adam, take it away.
Thank you to our guests for speaking with us today. To discover how the IMS team can help give your case an edge, check out imslegal.com or shoot us an email at contactus@imslegal.com. IMS has served trusted law firms and corporations worldwide for more than 30 years and over 65,000 cases. As a strategic partner for the full case lifecycle, our integrated teams provide specialized advisory support, expert witness services, litigation consulting, visual advocacy, and presentation technology to elevate strategies and protect hard-earned reputations. Learn more at imslegal.com.